Imagine this. You have lived in your home for 30 years. You raised your children there. You paid off the mortgage. You always believed that when the time came, the house would simply go to your kids. Then one day, something happens. A stroke, a fall, a sudden hospital stay, and your daughter rushes to the bank to pay your property taxes before the deadline, and the bank tells her no. She has no legal authority to touch your accounts. Meanwhile, the county sends a notice. Your property taxes are overdue. A lien is being placed on your home, and your son finds out that because you never filed one simple document, a stranger appointed by a judge may now decide what happens to the house you spent a lifetime paying for. This is not a rare situation. This happens every single day in America, and it is completely preventable. Hi, I am Milena, and I am a senior policy analyst specializing in retirement finance, estate protection, and the government rules that affect homeowners over 60. Today, I'm going to walk you through the 5 documents that every senior homeowner in America needs to file before it is too late. These are not complicated. Most of them are free to prepare, but if you skip even one of them, you could lose control of your home, cost your family thousands of dollars, or hand the decision about your property over to a courtroom instead of your kitchen table. Now, I need you to stay with me all the way to the end of this video, because document number 4 contains a hidden tax trap that catches thousands of families every single year, and most people have never even heard of it. Let me start by telling you about someone I will call Robert. Robert is 67 years old. He retired 2 years ago from a manufacturing company in Ohio. He owns his home free and clear, no mortgage, no debt. He always considered himself responsible with money. Robert had a will. He wrote it himself 15 years ago when his wife was still alive. After she passed, he never updated it. He figured the house would just go to his 2 kids, plain and simple. He never filed a durable power of attorney. He thought his daughter could handle things if something happened to him. She lived right down the street. He never filed an advance directive. He did not like thinking about hospitals and end-of-life decisions. He never set up a transfer on death deed or a trust. He thought that was only for wealthy people, and he never applied for his county's senior homestead exemption. He assumed it was automatic once he turned 65. Then last winter, Robert had a serious stroke. He survived. But he could not speak. He could not sign documents. He could not manage his finances. His daughter went to the bank. They turned her away. She had no power of attorney. His property tax bill came due. Nobody could pay it. A lien was placed on the home within 4 months. His son wanted to sell the house to pay for Robert's care. But without a trust, a TOD deed, or an updated will, the home was locked in legal limbo. The family had to hire an attorney and petition the court for guardianship. That process took 7 months and cost the family over $12,000. All of this, every single penny, every sleepless night, every courtroom appearance, could have been avoided if Robert had filed 5 simple documents while he was healthy. Let me show you exactly what those 5 documents are. Document number 1, a last will and testament. With your home. Specifically named according to the Consumer Financial Protection Bureau, a will is, and I quote, a legal document that sets forth your wishes for what should happen to your property and belongings when you die. The CFPB calls it the most common way to pass your home to your heirs. Now here is the shocking number. According to a survey cited by AARP, 67% of Americans do not have a will or a living trust. Among people aged 50 to 64, over 40% have no will. And even among those 65 and older, more than 30% still do not have one. Many seniors assume that because they verbally told their children who should get the house, a formal will is unnecessary. This is false. If you die without a will, you die what the law calls intestate. That means the state, not your family, decides who gets your home. A judge appoints an administrator, who may be a complete stranger, to distribute your assets. AARP warns, and I quote, when there is no will, there is a much better chance that there will be fighting within the family, as no one knows what your wishes really were. The AARP policy book adds that, without a will, probate is slower and more expensive, and may not reflect the wishes of the person who died because it follows set formulas. Your home could go to someone you never intended, or it could be sold just to cover legal fees. Now here is what protects you, a properly signed and witnessed will, and if you have it notarized, the AARP policy book says it becomes self-proving, meaning your witnesses do not even have to appear in court if someone challenges it. And listen to me carefully. If you are over 60 and cannot afford a lawyer, the CFPB says free legal services are available through the Elder Care Locator at 1-800-677-11-SKINKS. I will repeat that. 1-800-677-1116. You can also find them online at eldercare.acl.gov. Document number 2, a durable financial power of attorney. This is the document that would have saved Robert's family. The CFPB defines a power of attorney as a legal document that allows someone else to act on your behalf. But the word you must look for is durable. A durable power of attorney continues to work even if you become incapacitated. A regular power of attorney dies the moment you become unable to make decisions. The CFPB is very direct about this. They warn, and I quote, "If you don't create a power of attorney in advance, a friend or family member might have to go to court to have a guardian appointed if you become incapacitated. And that process can be lengthy, expensive, and very public." Now, AARP makes an important distinction. There is a durable POA that takes effect immediately when you sign it. And there is something called a springing POA that only kicks in when a doctor declares you incapacitated. AARP's financial experts recommend the durable version. Their advice is simple. If something happens, you want to be able to act quickly. And here is a trap almost nobody knows about. The Social Security Administration does not recognize any power of attorney. Let me say that again. Social Security does not accept a power of attorney. The AARP policy book confirms this. The Social Security Administration does not recognize powers of attorney. Instead, it will appoint a representative payee to manage another person's Social Security account. That is a completely separate process your family must apply for through SSA directly. Without this document, your property taxes go unpaid, your mortgage goes unpaid, your homeowner's insurance lapses, and your home is at risk, all because nobody has the legal right to write a check on your behalf. Document number 3, an advance directive. Living Will Plus Healthcare. Power of attorney. Now, this is not just a medical document. This directly affects your home. According to Medicare.gov, an advance directive has 2 parts. Part 1 is a healthcare proxy. It names someone you trust to make decisions about your health if you can't. Part 2 is a living will. It describes which treatment you want if your life is threatened, including dialysis, breathing machines, resuscitation, and tube feeding. Here is why this matters for your home. Without an advance directive, you have no say in where you receive care. A court or a hospital may decide you need to go to a long-term care facility, even if your wish was to stay home. And the moment you enter a nursing facility, you trigger something very serious. According to Medicaid.gov, and I quote, "For individuals age 55 or older, states are required to seek recovery of payments from the individual's estate for nursing facility services. That means the state can place a lien on your home to recover what Medicaid spent on your care. An advance directive gives your family the legal authority to honor your wishes, including keeping you at home when possible. Now here's the good news. Medicare pays for advanced care planning at no cost to you when it is part of your annual wellness visit. And AARP offers free advance directive forms for every single state on their website at aarp.org/cha, caregiving, financial legal, free printable advance directives. But here's the trap for snowbirds. The AARP policy book warns that advance directives from one state may not be valid in another state. So if you spend winters in Florida and summers in Michigan, you may need advance directives filed in both states. And one more thing. AARP cautions that a financial or healthcare power of attorney is only helpful if someone can access it when needed. Do not lock these documents in a safe deposit box that nobody can open in an emergency. Keep them in a secure but accessible place at home and make sure your family knows exactly where they are. Chapter from Document number 4. A transfer on death deed or a revocable living trust. This is the document that contains the hidden tax trap I promised to tell you about. So listen closely. According to the CFPB, a transfer on death deed is a legal document stating that upon your death, your home should pass to a specific heir. The CFPB says it avoids the costs and delays associated with the probate process and is usually simpler and less expensive than creating a trust. The alternative is a revocable living trust. The AARP policy book explains that trusts do not go through probate court when a person dies. Therefore, they transfer assets very quickly. They also are not public, ensuring privacy. Either option keeps your home out of probate court and out of public records. But here is where the tax trap comes in. And this is the mistake that costs American families thousands of dollars every year. Many seniors think, I will just add my child's name to the house title right now. That way, when I die, the house is already theirs. It sounds logical. But the CFPB warns that adding children to the title carries risks, including liability and serious tax consequences. Here is why. According to the IRS, when you give your home to someone as a gift during your lifetime, they inherit your original cost basis. So let me give you a real example. Say you bought your home for $80,000 40 years ago. Today it is worth $400,000. If you add your child to the title or gift them the home now, their cost basis is $80,000, your original purchase price. If they turn around and sell that house for $400,000, they could owe capital gains tax on $320,000 of profit. Now here is the protection. According to IRS publication 551, when your child inherits the home after your death, through a will, a TOD deed, or a trust, they receive what is called a stepped-up basis. That means their cost basis resets to the fair market value on the date you pass away. In this same example, their basis would jump to $400,000. If they sell the home for $400,000, their capital gains tax would be zero. Let me say that one more time. Gifting the home now could mean your child pays taxes on $320,000 in gains. Inheriting it through the proper documents could mean they pay zero. That is the difference between filing the right document and making the wrong move. And one more warning. The CFPB states clearly that transfer on death deeds are not allowed in many states. Check with your county recorder's office or an elder law attorney to see if your state offers them. If not, a revocable living trust is your best alternative. Also, pay attention to the timing. The CFPB warns that the timing of when you sell or gift your home may affect your Medicaid eligibility. If you transfer your home within Medicaid's look-back period, PCOS, which is typically 5 years, you could face a penalty period during which you are ineligible for Medicaid coverage of long-term care. That could be devastating. Document number 5. A Homestead Exemption Application. This is the document that saves you money every single year, and millions of seniors are leaving it on the table. According to the AARP policy book, Homestead exemptions reduce the amount of owner-occupied property value that is subject to taxation. Nearly every state in America offers some form of property tax relief to older homeowners, usually starting at age 65, though some states begin at 60 or 62. These programs can save you hundreds or even thousands of dollars a year. But here is the critical point. These exemptions are not automatic. You must file an application with your county assessor's or treasurer's office. And in many jurisdictions, you must renew it, sometimes every single year. AARP warns that anybody can forget to fill out the renewal notice, especially older adults who get a lot of junk mail. That one piece of mail you threw away because it looked like junk could be costing you $1,000 a year. And if you do not pay your property taxes, whether because you missed the exemption or because nobody had the POA to pay them on your behalf, the consequences are severe. Unpaid property taxes can lead to a tax lien on your home, and a tax lien can ultimately lead to a tax sale or foreclosure. You can lose your home, not because of a mortgage, but because of a property tax bill that could have been dramatically reduced with one simple application. The AARP Foundation offers a free property tax aid program that helps seniors in every state apply for these exemptions. You can find it at ptconsumers.aarpfoundation.org. I will put that link in the description below this video. And here is one more thing. The IRS wants you to know. If you are 65 or older, you can use IRS Form 1040-SR to file your federal taxes. It is specifically designed for seniors with larger print and prompts that help you claim property tax deductions you might otherwise miss. All right, I have given you a lot of information today. Let me make this simple. Here are the 3 things I need you to do this week, not next month, not next year. This week. Step 1. Gather and file your 5 documents. Get a folder, a physical folder, and label it Home Protection Documents. Inside that folder, you need 5 things. your updated will with the home specifically named, your durable financial power of attorney, your advance directive including both the living will and the health care proxy, your transfer on death deed or your revocable living trust documents, and your Homestead Exemption Application or proof of filing. If you do not have all 5 yet, start with the ones you can do for free right now. Go to AARP's website for your state-specific advance directive forms. Call the Elder Care Locator at 1-800-677-1116 to find free legal help near you if you are over 60, and visit your county assessor's website or office to apply for the homestead exemption. Do not let perfect be the enemy of done. Even filing 2 or 3 of these documents this month puts you miles ahead of where most Americans are right now. Step 2. Tell your family where the documents are and give them copies. This is just as important as filing them in the first place. AARP warns that a power of attorney locked in a safe deposit box that nobody can access in an emergency is useless. Keep originals in a fireproof document bag or safe at home. Give copies to your executor, your power of attorney agent, and your health care proxy. Make sure at least 2 trusted family members know exactly where to find everything. Also, and this is critical, if you receive Social Security, remember that SSA does not accept a power of attorney. Your family must apply separately to become your representative payee through the Social Security Administration. Have that conversation now while you are healthy so they know what to do if the time comes. Step 3. Review and update everything at least once every 2 years or after any major life change. A will you wrote 15 years ago when your spouse was alive may no longer reflect your wishes. A POA naming someone who has since moved across the country may not be practical anymore. And here is something that catches many families off guard. Beneficiary designations on retirement accounts and life insurance override your will. AARP confirms this. So if you got divorced and never updated those designations, your ex-spouse may still be listed as the beneficiary, no matter what your will says. AARP recommends reviewing your estate documents after any major life event, a death in the family, a divorce, a move to a new state, or a significant change in your health. Put a reminder on your calendar. Treat it like an annual checkup, but for your home. Let me repeat something that matters. Every single resource I mentioned today is either free or very low cost. The CFPB, Medicare, AARP, the Elder Care Locator. These are government-backed and nonprofit programs designed specifically to help people like you. You do not need to be wealthy to protect your home. You just need to file the right paperwork. Before I let you go, I need to tell you something important. The rules around Social Security, property taxes, Medicaid, and estate planning change more often than most people realize, and you cannot rely on YouTube notifications to keep you safe. Algorithms change, videos get buried, important updates can slip right past you. That is why I created something specifically for our community. When you join, you will also get a free downloadable copy of our Senior Benefits Protection Guide, a step-by-step checklist that covers everything we talked about today, plus additional resources you can use right away. Now I want you to do one more thing for me. Think about someone you know, a neighbor, a friend from church, a sibling, a parent, who owns their home and is over 60. Share this video with them. Send it to them right now, because the information in this video could save their home, save their family thousands of dollars, and save them from a courtroom they never needed to see. Hit the subscribe button. Turn on the bell so you never miss a video, and leave me a comment below telling me which of these 5 documents you are going to file first. I read every single comment, and I am here to help. I am Milena, and I will see you in the next one.